Okay, in the matter of people versus Eric Martin. Mr. Martin, can you hear us?
Yes, can I get the first case number of the so-called case that never was given a copy of the ticket by the police officer, which he should have in violation of my due process right?
241388 SM.
241, what else?
38 SM.
38?
1388 SM.
24138 SM. Right?
Yeah, 2 weeks.
Okay. All right, thank you.
I do have in front of me a complaint charging with domestic violence violation of city code. It's misdemeanor. Oh, I see January 24th, January 10th. Okay, you pleading not guilty, Mr. Gazicki?
That's John James Gazicki. Mr. Martin expressed his right not to be represented by a court-appointed attorney. He wishes to represent himself.
This case is one of those rare moments where sovereign citizen fantasy collides head-on with courtroom reality. And spoiler alert, reality is undefeated. Eric Martin has been on a personal crusade across multiple courts, multiple cases, and now a fresh domestic violence charge that finally has him stuck in jail long enough to hear himself talk. Today, you're going to see him do everything except what actually helps him. Answer questions, follow procedure, or acknowledge basic law. Instead, he insists he is a living man, claims jurisdiction doesn't apply to him, and somehow believes judges can be fired mid-hearing like retail employees finishing a shift. What makes this even wilder is that Eric doesn't just reject lawyers. He rejects the very idea that he's the defendant, despite his name being on the case and his jumpsuit matching the decor. Across today's hearings, watch how he tries to out-argue trained judges, demand the arrest of police officers and judges, and treat criminal court like a Facebook conspiracy group. But pay attention closely. Beneath the theatrics are real stakes, jail time, victims, and legal consequences he keeps pretending don't exist. Buckle up, because this sovereign citizen roller coaster just left the station and there are no brakes.
Okay. Is that right, Mr. Martin?
Present myself here.
Okay.
Because I don't want to give up my right to be one of the sovereign people, as the U.S. Supreme Court said I have a right to be. So.
Okay. I'm going to let you do that. I don't care why. Have you talked to the prosecutor?
No, I have not.
I want you to get the prosecutor and have her talk to Mr. Martin, and let's see what we're going to do today.
All right, so I would like to talk to him about how the case should be dismissed based on there's no evidence.
This is the classic sovereign citizen negotiation style. Don't answer questions, reject options, claim there is no evidence, then act shocked when nothing gets resolved. The prosecutor walks in ready to discuss reality, evidence, charges, possible outcomes. Eric walks in ready to discuss imaginary law, personal sovereignty, and how none of this counts because he didn't consent to existing in the United States. Notice how quickly he jumps from case should be dismissed to everyone should be arrested except me. This isn't legal strategy, it's courtroom cosplay. And the fastest way to ruin your own case is to treat the judge like a debate opponent instead of the person who literally determines your future.
A matter of people versus Eric Martin.
Okay, thank you.
Mr. Martin, can you hear us?
Yes, I hear you.
Okay, Mr. Prosecutor, you want to put your appearance on record?
And good morning, Your Honor. Omar, or good afternoon, Your Honor. Omar Shah on behalf of the people, PA 6332.
Okay. You've had an opportunity to talk to Mr. Martin?
That is correct, Judge.
Been able to resolve this matter?
Judge, there is no resolution on this matter. I had an opportunity to speak with the defendant in this case. He wishes to have a jury trial or a bench trial. He just doesn't know which one he wants.
Okay, Mr. Martin, which one do you want? I'm going to set this over for a trial. You want a jury or the judge to hear it?
Well, I don't really want to answer that question. I don't want to be fraudulently presumed I'm consenting to any of these proceedings. You know, I'm not consenting to have my right against slavery violated by consenting to any proceedings. So that's why I kind of want to answer that question. But before I get to, as I notified the prosecutor, he should have dismissed the case due to lack of evidence. But I had one more thing I wanted to point out to the prosecutor. I forgot to mention to him. I want to mention to him now, and that is I want the police officer, Bardaway, who illegally arrested me, I want him charged for the legal arrest, which is assault and battery. And also Judge Shackelford, who did not give me a personal bond. I want her arrested too for violating my right against kidnapping and allowing this unlawful incarceration of me, which I have a right to do. And if they refuse to do it, I'm also going to move for dismissal on the case because it's violating my right against equal protection, because I have the right to have charges brought against people who have committed crimes against me also.
Here is where you see how sovereign citizen ideology completely backfires. The judge gives him a simple, procedural choice: jury trial or bench trial. Any normal defendant would pick one in seconds with the advice of counsel. Eric, however, believes even answering the question somehow creates jurisdiction, so he refuses to choose anything. The problem? Courts do not freeze just because someone is philosophically confused. So the judge makes the decision for him. This is the irony sovereign citizens never grasp. By refusing to participate, they don't stop the process. They simply remove their own control over it. The train still moves. They just refuse to stay.
Okay, based on that, I'm going to indicate that you want a jury trial. I'll set this matter over. I'll have the assignment clerk set a date. She'll send you a notification of the date for the jury trial. In the meantime, I'm going to continue your bond until that day. You go with the sheriff, he'll take care of you today.
Hold on, objection. I have a motion to make that I have a right to a personal bond.
You file that motion in writing, and I'll take a look at it.
I already did file it with
In the meantime, I want you to go with the sheriff, and he's going to take care of you.
Hold on, object. I have some. I already filed it with the court. I'm making that motion now. I'm making that demand actually now because it's a constitutional right to be innocent without guilty. All right, then I'll be taking your job. How about that? Because you violate my constitutional right, and I move to dismiss you off the case, disqualify you. Since you violate my due process right to a personal bond, then you showed your biasness, and you should not be in the case no more. I move to disqualify you. If you deny that motion, I request that you send it to the State Court Administrative Office. You're not supposed to continue my bond with monetary award. Shackelford illegally denied my personal bond, and you're not supposed to continue that illegal denial. I have a constitutional right to be presumed innocent, and that means the right to a personal bond. Article 3, Section 1, judges that violate the Constitution cannot hold office. So don't grant that motion if you want to, that demand. I'll be to get your job in a lawsuit. That's all I got to say. So you want to continue with that? Sound like they muted me, maybe. Well, these judges are going to find out. They're not above the Constitution.
This is the moment where Eric leaves the planet entirely. He doesn't just argue his innocence. He calls for the arrest of the officer, the judge, and basically anyone who failed to treat his YouTube law degree as valid authority. He claims kidnapping, assault, battery, unlawful incarceration, yet offers nothing but his personal outrage as proof. Courts deal in evidence, not declarations of cosmic injustice. And here's the dangerous part. When defendants adopt this mindset, they stop focusing on their own charges and start believing they're the real victim of a grand conspiracy. That's how cases that could have been minor explode into long sentences.
Position, Judge.
All right, so Mr. Martin, you are waiving the House Counsel?
Yes, due to, so I'm not fraudulently assumed to be the defendant, a living man, not the legal fiction corporate entity defendant, which I couldn't possibly be. I know due to canon law being, unfair, it's gonna, you guys fraudulently assume that if I take an attorney. So that's the unfairness why I can't accept attorney because of that.
Sure. All right, and you understand all of your constitutional rights?
I do my best to. I've been studying, practicing law 28 years.
All right. That's all right. So, looks like this is, ready to be set for a, jury trial, is that right?
Yeah, but I wanted jury trial of my peers means of the sovereign people, not U.S. citizen slaves who most probably everyone of the jury probably say they are. So.
As the individual who determines questions of law, that's me. I will make sure that it is a jury of your peers. So, and I'll determine that. So we will have this set, and then I'll mail out the date for the jury trial.
I believe there's a date set for next Tuesday for the jury trial in this matter.
All righty, I see that.
I have objections. I cannot probably prepare for trial in this jail. I've been illegally denied my constitutional right to a personal bond, even though it's my constitutional right because it's part of my right to be innocent before guilty. It's been denied so far. I have no money to pay for a bond to get out of here. So that's especially why I also should be given a personal bond. And like I said, I cannot probably prepare for one in here, you know?
So you're in there for a different matter, because I set your bond at $100 personal before on this matter. So it's whatever's keeping you in jail isn't this case. So we'll see it. I understand though that you do need to prepare for trial. I get that part. So we'll go ahead and adjourn the jury trial. When is your out date? With whatever you're doing there?
There is no out date. That's the thing. It's So is this about the moped case?
Yeah, this is driving while your license is suspended.
I wasn't sure. Right, they got me legally confined right now in the domestic violence. No evidence at all. She lied, made a statement. So now
hold on, Mr. Martin, hold on. Even though this is a different court and that's not my case.
Right.
You have the right to remain silent. Anything you say can be used against you. I just want to advise you of your Fifth Amendment right again. And so I suggest not bringing up the other case. This case here is on the moped and the driving on a suspended license.
Right.
So a revoked license.
Okay.
So what I'm saying is you need time to prepare on that one. I don't know what the situation or status is of the domestic violence case. But you said that you're on bond. You haven't posted your bond on that case. Is that what you're saying?
Well, I'm not even sure. I think that the judge said a monetary bond. I wasn't sure because she unprofessionally drew the thing away from you want to call it this the remote Zoom thing away from the door before I could read the hearer. But it sounded like she told the police officer $2,000, but I'm not even sure. I got no money to pay a bond, no way, even if it's $1. So,
what you're seeing here is the natural end stage of sovereign citizenship, the moment where frustration turns into open hostility. Eric doesn't just object. He threatens lawsuits, demands the judge's removal, and claims he'll take their job. Judges hear legal arguments every day, but what Eric is doing is an argument. It's tantrum disguised as constitutional language. When he says he has a right to a personal bond no matter what, he's ignoring why bonds exist in the first place, to protect the community and ensure court appearance. Threats, interruptions, and delusions of legal superiority don't convince judges. They confirm exactly why strict conditions are necessary.
I am allowed. I don't have nowhere else to live. That's my house. I'm allowed there. You ordered that. That violates my due process.
All right. He has a $2,000 cash bond with a GPS tether.
Yes,
and he's not to
return.
Personal bond. He's not to appear at 9.
Innocent without guilty.
He cannot come to 9074 Clifford or be in contact with Crystal Martin.
So, right, because they illegally deny my personal bond, this is why I'm still in here. So, but yeah. So.
All right. So what I'll do is, I don't know when that case is next. The next day, is that it's a state case? Ms. Manarino, you don't have that case, right?
I don't
so
know.
it must be a state. All right, and so it must be a state case, which means it's on a Monday. So that's probably going to be resolved within a month. So let me go ahead and set this for jury trial. No, there will be no need to set it for a settlement conference before that. But
Well,
let's
I
get
object to that. I won't touch up. I was going to object before you guys don't give me a chance to talk. I object to like it should be. I moved that to be stayed. This moped case till I get out of prison. I mean, till I get out of jail here. I can prepare myself. I can probably prepare myself.
Right, that's right. Listen,
Ask some of my legal authorities to argue nothing.
It's being set for jury trial.
The one
It's
is-
from yesterday.
Okay, so when is that one?
They didn't set it.
Okay. All right, so I'm gonna set it for a jury trial, but if you're still in jail at that time, then I'll just adjourn it again so that you can prepare. I'm not worried about that. So, I mean, but I can't do anything about your other case is what I'm saying. So I'm looking at, as far as a date right now, I just want to put a date on the books so that we know that you have an idea. I mean, if you get out tomorrow, then you'll know and what your date is. So I'm looking at, let's see. And I don't have the availability to check with my clerk because my criminal clerk is out this week.
Your Honor, we do
So
other
go ahead.
I'm sorry, Judge. We do have other jury trials scheduled on your docket on July 9th. I don't know if that's too soon.
That's probably going to be, and it's only a couple of weeks away. So I don't know what his situation is. And even if he gets out in a week, that only gives him a little bit of time. I want to make sure he has at least a couple of weeks to, I mean, it's a driving on a restricted license. So it's not exactly a whole lot of prep time for that. It's not a homicide case, but
Whenever someone brags about studying law for decades yet can't answer the most basic courtroom questions, that's your first clue that their education came entirely from internet forums. Real legal study teaches procedure, respect for the court, and how to work within the system. Eric's version teaches him that words like sovereign, living man, and corporate fiction will magically dissolve criminal charges. But watch the judge here. Calm, patient, and unmoved. Judges have seen hundreds of self-proclaimed legal scholars who discovered law through conspiracy videos. Experience has taught the court one simple truth. Confidence is not competence.
so I'm looking at August 13th. Because I'm trying to pick a date that's outside of probably where I'm already scheduling stuff at, because I don't have my criminal clerk here to kind of check and see like where I'm at with things. So we're going to set this for August 13th.
Thank you, Your Honor.
And I know that we'll set that at 8:30 in the morning, August 13th. All right. Mr. Martin, let the deputy know that you're all set, and we'll be mailing out the notice to you, sir.
Thank you, Your Honor. All the best to you and your staff.
Say again?
That's something I want to say to with the prosecutors here. Dealing with this other case that I'm here for now, I request that
Not the same prosecutor. Not the same prosecutor. That's the state prosecutor.
They're Taylor prosecutor.
Your other case, are you talking about your other case? Your other case is a state case. So that's a Wayne County Prosecutor's Office.
No, so
Not the city attorney.
I'm talking about
Okay.
the case I'm in here now. I want them notify the prosecutor that I want charges filed on Crystal Martin for bringing these falsified charges against me now, and also for assault and battery that I have on video camera for. Just so you know what I mean. And she keeps bringing this
Again, that's the other prosecutor. That's a different prosecutor's office, sir.
because it's my equal protection right to bring charges too. They want to bring charges against me, but they don't have no evidence. And I do, and I should be suffering here in jail as a lack of evidence as a result by and the unequal protection clause.
And that's on your other case, sir. So,
But
let's-
it's still a right though. It's still my right to tell the prosecutors this and have them act on it. And if they
No,
don't,
this isn't-
that's
this
going to
isn't-
certify a defense.
This isn't the proper prosecutor. That's the Wayne County Prosecutor's Office on your other case, okay? This is the city attorney. Okay?
They're the
Deputy, have a good rest of your day to you and your staff.
Thank you, Your Honor.
Thank you, Your Honor.
McMullen, case, the motion to set aside. Let me bring them up. People versus Martin, case 241388 SM. Today's the date and time set for a settlement conference. Also, there was a motion by Mr. Martin, motion to dismiss the case. Court has read through the motion. There was no accompanying brief in support. Well, there's also objections to the denial of the personal bond. I'm going to consider that as a motion for reconsideration. All right, Mr. Martin, was there anything else you wanted to place on the record, sir?
Oh, yes. Well, first, I'm not the fraudulently assumed defendant. I am a living sovereign man.
I can see that you are a living man. You are currently talking, and we are having a conversation. So, okay.
Right, but John, under the law, there's fraudulent presumptions under canon law 3228 that, that say otherwise, and there's a lot of support what I'm saying. So that's why I say what I say to the record. But anyways, yes, I do have other things to say. First, I also want to file a demand to dismiss this case based on speedy trial violation under Mission Court Rule 6.04C, 28 days for speedy trial in misdemeanor cases. I've been in jail over that since the 8th of last month.